FIIG Securities was fined $2.5 million for cybersecurity failures. But for most firms, the fine is still cheaper than compliance. ASIC sued FIIG Securities. The federal court called the failures systemic and prolonged. 18,000 clients were exposed. But the breach was not the failure. The court's findings pointed to the real failure: years of governance-approved underinvestment. The penalty was $2.5 million. For many firms, that number looks cheaper than prevention, which means every compliance officer now faces the same boardroom question: why fully fund cybersecurity if failure costs less? Every Australian financial services licensee operates under Section 912A of the Corporations Act. 3 obligations: maintain adequate technological resources, have adequate risk management systems, provide financial services efficiently, honestly, and fairly. Those are not cybersecurity regulations. They are general licensing conditions. FIIG Securities held that license. Fixed income specialist. Bonds. Term deposits, institutional debt, approximately 18,000 clients. The federal court found FIIG failed all 3 obligations simultaneously. Not one area, 3 governance failures across resources, risk management, and service delivery at the same time. And the court found these failures were not recent. Systemic. Prolonged. They predated the breach by years, which means the liability did not begin when attackers entered the network. It began when the governance structure approved the conditions that let them in. In 2023, attackers breached FIIG's network. Approximately 385 gigabytes of confidential client data was exfiltrated. Names, addresses, financial details, account information. That data ended up on the dark web, but the breach was the consequence, not the failure. Every year, someone approved the technology budget. Every year, someone certified risk management as adequate. Every year, someone signed off on service delivery. Those governance acts, board decisions, compliance certifications, risk committee approvals, created the attack surface. Year after year, the court did not punish FIIG for getting breached. It punished FIIG for the years of decisions that made the breach inevitable. If you approve technology budgets at a regulated firm, your signature on a budget that a court later finds inadequate is not a business decision. It is a liability event, and the clock started the day you signed. The federal court imposed the $2.5 million penalty. However, the penalty is not the precedent. The court ordered an independent, expert-led cyber resilience remediation program, effectively placing cybersecurity governance under external oversight. An expert chosen independently, not by FIIG, would review and rebuild the firm's entire cybersecurity governance. FIIG would pay for it. FIIG would comply. FIIG had no choice. The court concluded that FIIG's internal governance was so structurally inadequate that it could not be trusted to fix itself. The regulator did not ask FIIG to improve, did not set a deadline for internal reform. Instead, they put someone else in charge of fixing it. Your firm pays the bill. Your board loses control of the remediation process. That is a more severe consequence than the fine. The fine ends. The external oversight changes who controls your firm's security architecture, and that precedent now exists. Now run the numbers. $2.5 million. For years of underinvestment and 18,000 clients exposed. For a financial services firm of FIIG's size, what would adequate cybersecurity have cost over the same period? Dedicated security staff, infrastructure hardening, monitoring systems, incident response, Penetration testing, compliance documentation. For many firms of this size, multi-year cybersecurity investment would likely exceed that penalty, which raises an uncomfortable question. Are the economics of underinvestment more favorable than the economics of compliance? That is not a firm-level problem. That is a deterrence problem built into the regulatory framework itself. ASIC requires cybersecurity compliance under general licensing obligations. The court penalizes failure, but if the penalty falls below the cost of what the regulator required, the framework simultaneously demands compliance and makes non-compliance the rational economic calculation. Every compliance officer watching this now has a board conversation to prepare. Your board will ask, if the fine for failure costs less than compliance, why are we investing? You need an answer, because the board's math may be correct. ASIC has already filed a second enforcement action, Fortnum Private Wealth, allegedly failing to adequately manage cybersecurity risks. Same legal framework, same general licensing conditions, same theory of liability. This is not a one-off case. This is a pattern signal. And the enforcement theory ASIC used, general licensing obligations, not sector-specific cybersecurity regulations, maps by analogy to equivalent frameworks in every major financial jurisdiction. The UK Financial Conduct Authority holds regulated firms to adequate resources and fair treatment standards. The US SEC and FINRA hold broker-dealers to supervisory and operational obligations. BaFin in Germany holds licensees to organizational requirements. MAS in Singapore holds financial institutions to technology risk management standards. The governance-approved underinvestment pattern is not Australian. It is structural. It exists wherever a financial regulator holds licensed firms to general obligations that include adequate resources and fair service delivery. If your firm is a licensed financial institution anywhere, the question is not whether your regulator will use general licensing obligations to enforce cybersecurity compliance. The question is when. The lesson from FIIG Securities is not about cybersecurity. It is about governance approval. Every budget decision your board makes about security controls is now, demonstrably, a compliance decision with enforcement consequences. The liability does not start when attackers arrive. It starts when the board approves the budget. If you sign risk certifications, if you approve technology budgets, if your firm holds a financial services license, your cybersecurity budget is not a cost center. It is a licensing obligation, and regulators are now enforcing it. Sources for this episode, including the federal court judgment, ASIC media releases, and the Section 912A framework, are linked in the description and pinned comment below. This is Scam Beast.